I think that's my cue. So welcome everyone. I was going to say good evening. It's evening here, but I think we're juggling multiple time zones. So whatever time it is your end, welcome to this event. My name is Max Delmar, and it's a really great pleasure for me to be chairing this symposium on Gerald Postema's new book, Law's Rule, The Nature, Value and Viability of the Rule of Law. It's just hot off the press. Certainly here in the UK, it's hot off the press. So we're delighted to have an event on it. And if you've not read it, then this event will give you a taste of the arguments in the book. This event is co-hosted by the Universities of Queen Mary, University of London, and the University of Edinburgh, and also the UK IVR. Can I just ask Thanks so much. And I just wanted to thank Neil Walker and Noam Gore very much for their support and enthusiasm for the event. And I very much hope that we can continue to collaborate in the future. So we have with us this evening, as I think you can see, Gerry himself. So Gerry, thanks so much for being here. And we also have four wonderful commentators with us, Neil Walker and Cormac from Edinburgh, Nicole Roughan from Auckland, and we're very grateful to Nicole for getting up at an ungodly hour in the morning to be with us, and Hans Lindahl from Tilburg and Queen Mary. I hope the commentators can forgive me for dispensing largely with introductions. I think we're keen to discuss the book, but I do want to say that it's a really great personal pleasure for me to be chairing this event on Gerry's book. I've been reading, admiring, and trying to learn from Gerry's work for some time. He's a very prolific scholar, so it's impossible to keep up with him. But I recall reading still as a student his book, 1986, Bentham and the Common Law Tradition, and very much admiring the mix of history and philosophy, intellectual history and philosophy in that book. And I remember particularly enjoying his two chapters on Hume, and to which I've been returning throughout. And if you haven't read his 20th century history of legal philosophy in the common law world, then I really recommend it. It's a wonderful guide to not just the usual suspects, I would say, but also to a number of figures and texts that have been very much neglected in history of legal philosophy, including some Scots. I just thought I'd mention that, seeing we're co-hosting with Edinburgh. I remember learning about Miller's Data of Jurisprudence from that book. Such a wonderful book that's neglected still. And peppered throughout Gerry's work are also all sorts of references to music, and I love his musical metaphors and analogies. And I note that in this book too, the book ends with a musical term, Azaka. But I'll let Gerry explain, perhaps, if you would like to, why that's so. I'm really delighted to be chairing this event, and just to explain the format, we're going to begin with a short introduction from Gerry to the book, and then we have two panels. In the first panel, we'll hear from Neil and from Cormac, and invite Gerry to give a short response if he'd like to, and have a little bit of discussion depending on how much time we have. Then a short 5-minute break, and then we have our second panel with Nicole and Hans. So that's the program, and hopefully at the end we'll have some time for questions as well. But without any further ado now, Gerry, would you like to tell us a little bit about your book?
Max, thank you so much for your introduction and for your invitation and organizing of this splendid event. I'm honored and very grateful. I'll talk about music later, perhaps. What I'd like to do now, just in a few minutes, is not to summarize the argument, that would be too complicated, but to give you some idea of the ambition that drove Law's Rule. The occasion for it, of course, is kind of obvious now. The idea of the rule of law has been under contestation for a very long time. there's a dizzying array of proposed standards for the rule of law. It's deeply disputed, both about its content and the scope of its principles among scholars for a long time, and more recent decades amongst politicians, national leaders. Not only is there a debate between the thick and the thin forms of it, but there are proposals for authoritarian rule of law and things like that. Political ideals with this kind of scope and power and visibility are hotly contested, not just at the periphery, but at its core. Another problem here is that there's an outright challenge of two different kinds. One is attempts, we're now very familiar with them, attempts to erode or subvert the rule of law in various respects. Hungary, Poland, Brazil come to mind, Israel more recently, and of course the US in various respects. But also an attempt to capture the ideal. Dante once said that justice is so lovely that it's loved even by its enemies. And I think the same can be true for the rule of law. Although the rule of law ideal imposes irritating constraints on those who exercise power, it enjoys a halo of legitimacy. And as a consequence of this, it's very vulnerable to capture and rhetorical abuse by those who want to retain that halo and minimize its costs. It's so widely used and abused that in some sense, we literally don't know what we're talking about, or maybe don't care. Never, it seems to me, is it more important to seek to understand the rule of law. Now, there are a couple of strategies for responding to these challenges. One is despair, just give it up as a matter of ruling class chatter, or seek some kind of empty ecumenism, you might call it rule of law light, where there's an overlapping consensus of all these contenders. Or the alternative we often find is bold assertion backed up by fervent conviction without support or argument. And then, of course, there is the weakness, especially of those of us in the analytic legal philosophy context, of engaging in a kind of conceptual legerdemain, seeking for a definition which just excludes everyone else from the conversation. My strategy is different. I think under these circumstances, we have to go back to first principles, but contend on the contested normative domain, and there articulate and defend a comprehensive and I hope compelling conception of the rule of law. So the aim is not to silence contestation, but to engage it. And in particular, to engage it by describing a framework for fruitful contestation, identifying different points where disagreements can be focused and progress perhaps made towards resolving the disagreements, and proposing and defending key substantive ideas at each of these points. So the ambition is to start with a small set of orienting ideas and articulate and defend a conception in 4 layers, you might say. First, it identifies or defines an architectural frame for pursuing a substantive conception. Then it proposes to fill out that frame with some substantive ideas and principles, and then sketches a set of institutions and practices that illustrate how that ideal might be realized in some particular political communities. And finally, to address and assess persisting threats to the viability of the rule of law and challenges to its intelligibility and normative force. Throughout, my aim has been to seek to account for the appeal and the normative force of the rule of law, recognizing at all times its complexity, and to locate and structure contestation about its intelligibility, its content, its normative force, and its viability. Now, the orienting thoughts are really 3, maybe 4. First, the rule of law I'm suggesting the rule of law surely is a very important ideal of political morality. though one amongst others, it makes serious, strong demands on political communities, on their political and other institutions, on officials, and even to a certain extent on ordinary citizens. And that is realized in institutions and practices of each political community, subject to the material and cultural and political variability of those communities. That's one point. The second orienting idea is that the rule of law at its core is concerned with power, with its arbitrary exercise, not with disorderly behavior, but with disorderly power. And it engages the law in the enterprise of tempering or disciplining that power. Also, it recognizes that law and formal legal institutions, however, are impotent on their own to do this work. They can only do so when they are animated by people who are committed to an underwriting ethos. So those are the orienting ideas. The structural frame of the conception can be distinguished in three parts. Actually, the cover of the book attempts to capture this. First, there's the core central idea, the central concern, articulated in what Martin Krieger calls a teleological form, a form of the aim of it and the means chosen to achieve that aim, plus a small number of rather abstract, quite general principles that serve that aim. Then to go upstream, as it were, a bit, to identify moral foundations of this idea, grounding the normative force of its principles, and situating the rule of law in the larger constellation of key values of political morality. And then explore institutional realization of this ideal in specific communities. These are often reported as part of the concept of the rule of law, but in my structure, what I'm suggesting is that they emerge as various, perhaps alternative ways of articulating and realizing the rule of law, given the particular features of specific political communities. And so design and defend the institutions. When doing so, we must be mindful of the specific cultural, material, and political conditions of these communities, the historical circumstances of behavior meant to be governed by the rule of law, but also mindful of the potential limits of the rule of law's demands, always guided by the general principles that lie at the core and the values that ground those principles. So here are my substantive proposals, very, very briefly. The core, the aim of the rule of law is to discipline, I say, offer protection and recourse against the arbitrary exercise of power, through the means being through the distinctive instrumentalities of law. This immediately implies, I think, three principles. One principle answers the question, who is disciplined by the law and how are they disciplined? This is the notion of the sovereignty of law. Three sub-principles are legality, that is, rule must be ruled by or through the law. Reflexivity, those that govern with law must be governed by it. And exclusivity, governing power is legitimately exercised only when it's ordained and ordered by the law. The second principle identifies who the beneficiaries of this rule of law are, and I use the notion of equality here to capture this. Equality not of a generic sort, not of economic distributive sort, but equality in the eyes of the law. So the point is those who are subject to the law must also benefit equally from its protection and the recourse that it offers when power is abused. Finally, we ask the question, how could law's rule even be possible? And for this, I propose what I call fidelity, which is the animating spirit of the rule of law. The set of convictions and commitments articulated and shared in shared responsibilities specifically to hold each other accountable to the law. And this is a community-wide ethos, engaging and binding officials, quasi-officials, and ordinary citizens, and the civil society organizations of them. The moral foundations I maintain and argue is that the rule of law rests on and is grounded in a more general but fairly complex value I call membership. This is a complex of interrelated and mutually limiting or qualifying values, specifically individual dignity, equality, or as I call it, peerhood, freedom as non-domination, and community marked by inclusion and mutuality of concern and responsibilities. And I spent a good bit of time trying to spell that all out. The institutional realization of the rule of law, then this is the third component in this strategy. I tried to set out institutions and practices that are necessary or especially useful to realize these ambitions. The tasks here involve identifying kinds of variability to which such realization design must be mindful, identify general guidelines for such design and highlight potential pitfalls, identify important challenges or tensions within the rule of law ideal itself and between the rule of law and other key values. And then I go on to assess and address challenges and threats to the rule of law, threats to its health and viability, challenges to the intelligibility and the very point of pursuing the rule of law, for example, in the transnational domain, challenges, what I call challenges for the rule of law, which have to deal with those tensions within it and between the rule of law and other ideals. I have a chapter on the role of mercy and equity in law vis-a-vis the rule of law demands, or the tension between dissent and deference to authority. And also seek to define genuine limits of the rule of law, sometimes where the demands of the law are overridden by other considerations. There's a recurring theme through this whole discussion, and that's the necessity of responsible judgment. I don't offer a manual for constructing rule of law institutions. I don't offer bright line solutions or resolutions of the tensions. I try rather to shine a bright light on those tensions, make clear what the stakes are, and identify where possible guidelines for resolving them. Throughout, the emphasis is on the need for careful, deliberate, nuanced judgment by individuals, by officers of government and organizations, and by collectivities. The importance of fidelity for the rule of law, in my view, and the importance and complexity of the rule of law ideal make individual and corporate responsibility and integrity among the most important, even signal virtues underwriting the rule of law. And their absence, I think, is one of the most serious threats to the rule of law in a political community. I end up the book by saying, we're not going to conclude this movement of the symphony with a long caesura. You're going to go right into the business of working on it. The movement is from movement 3, Attacca, to movement 4. We got to get on with the business of defending and constructing and vitalizing the rule of law in our communities. Thank you.
Brilliant. Thanks so much, Jerry, and for including the explanation of the musical term right at the end. So, fourth movement we are in, and Neil, the floor is yours.
Okay, thank you. I'm also delighted to be here. I also had my introduction to our author's work through his work on Bentham. It was also a long time ago, but and I've read a lot of his stuff since, and always been very, very admiring of his work. And many of the things which I always enjoyed in his work, the kind of the easy erudition, the range of reference, the wonderful style, the complexity of argument, which leaves you impressed rather than confused. Well, sometimes both confused and impressed, but always impressed. And they're all here in this book, and as I expected them to be. I got a lot from this book, and not just because of the kind of signal intellectual virtues of the author, but also because I was actually doing a new course on the rule of law, a new master's course this term, so it was good timing for me. Unfortunately, the book came too late to be included in the readings, but it will be there next year. And actually, that is an important point for me, because the two things I want to focus on both depend upon a kind of critique of the existing literature, which I think Jerry's book goes at least some way to overcoming. And the first has to do with the fact that and the more obvious one is that the second part of the book is actually really, really useful for anyone who wants to do case studies on the rule of law in particular contexts, whether it be IT, which is a particularly good chapter, or emergency powers, or international law, which I'll come back to in due course. Really, if you look at the literature as it is, apart from the book by Jens Meyer-Henrich and Martin Laughlin, which is the Cambridge Companion book, which has some really nice case studies of these specific areas, there's really not much out there, or I couldn't find that much, and so it was really useful to have this. So even if for any reason you don't read the, I think Jerry said, you have to read the whole of the first part of the book, but in the second part you can be more choosy if you want. If you want to be really, really choosy, you could also read parts of the second part of the book and get a lot out of that without necessarily reading the first half. Not that I would advise anyone to do that, but I'm just saying that if your particular interest is the digital age or whatever, then there's a fantastic chapter there, and also the chapter in international law is very good. So that's one reason why it was particularly useful for me. The other reason is a bit deeper, and it has to do with the fact that confession time, having read a lot on the rule of law over the last 2 or 3 months, probably with more intensity than I'd ever read on the subject, I found a lot of it quite repetitive. And of course that's what happens when you read a lot on anything. It is repetitive, but I thought there's something structural about its repetitiveness, which I have to kind of get to the bottom of. And I think I did, and I think it illuminates what is quite novel and interesting about Jerry's book. And the point is, for the most part, people treat the rule of law very, very much as a kind of middle level concept, within legal and political theory. And what you find is that much of the debate is around the kind of opposition which Martin Cregier, who's written more on this subject than probably just about anyone, his kind of the tension which he's been looking at for a long time between the idea of the rule of law as a set of orientating values on the one hand, and a set of kind of institutional structures on the other, and the fact that so many people who work in this area at different levels basically oscillate between these two different sorts of, points on the continuum. And so for many people who follow Cregier, it has to be about values, because institutions, of course, are just mere shells without the values. But for others, it's very, very much about the institutions, because, either the values aren't present, or because they're involved in, say, the politics of rule of law transfer or transmission or whatever, they're very, very focused upon institutional factors. And so what you get is this kind of two-way debate between the values, which always have to do with something to do with, overcoming arbitrary government, etc., and institutions which have to do with judicial independence, etc., and very, very quickly get into kind of mainstream sort of constitutional analysis. Now, Jerry does all of that, right? He does all of that, and he does it well. But of course, he does more than that, because he goes, in his own language, he goes upstream, right? He goes upstream of this middle level concept. He goes upstream of this idea, which he gets from Quigere in the 21st century and Bracton in the 13th century that the rule of law is just a middle level value to do with the tempering of power. He wants to go beyond that. He wants to go above that. And I think this is a quite valuable, but also quite an audacious move, because it's a difficult thing to do. I mean, the reason why a lot of people stay at the middle level of this sort of theorization is that they think that if they go higher, if they go upstream, then it leads to a kind of inevitable thickening of the rule of law, that the going upstream is going to take them in the kind of thickening direction that many people say undermines the value of the rule of law. It's got to stay thin, some people say, because if it doesn't stay thin, then it just becomes a replacement for general political morality, in which case you cannot impose it as a kind of neutral value within the debate, etc., etc. Gerry doesn't accept that. You know, he wants to go upstream, but he wants to go upstream in a way which he thinks will be valuable. And here I would say, you know, there's an aspect to his work which I'm not entirely misusing the kind of Rawlsian idea of reflective equilibrium here, I don't think. I think there is a reflective equilibrium between his really quite thick middle-level theorization of the rule of law and what it gets in terms of the upstream dimension. Now, he's already explained to you something of the middle-level conception of it. If I can just repeat that, because it's complex and sort of people will probably quite like to hear it more than once. This idea that the rule of law, you know, comes with these three core ideas of sovereignty, equality, and fidelity. I mean, the sovereignty of law is such a fundamental notion. I was actually thinking that the title of the book, Law's Rule, you know, makes it more apparent than the rule of law, partly, but maybe just through lack of familiarity, that we're actually dealing with the meta question of whether law can actually rule. We're not dealing with law's ruleness itself. We're dealing with the meta question. And I think that comes through very, very prominently in the title. And the notion of the sovereignty of law makes that very, very important. The idea of legality, exclusivity, but also reflexivity, you know, which is the basic idea that those who make the law are also subject to the law themselves, are really, really three very, very important ideas. I would say these are the more fundamental aspects of the core idea. Equality is there, and equality is important. I'll say a bit more about it in a moment. Fidelity is I think, in a way, it's a nod to two things. It's a nod to the fact that this is something which has to be taken seriously, but it's also a nod that you need to the fact that you need all of the kind of sociological undercarriage there to make this possible in any particular context. And that's obviously very, very important. Now, at the higher level though, as Gerry mentioned briefly, we have this notion of membership. And at first I thought, I'm not so sure about this. You know, is this going to work? You know, and one of the first things that Gerry says here is that other people have thought about these higher level values, but when they have, they've tended to go in the direction of a fairly thin conception of liberty or freedom, right? And of course, the point there is that there's a kind of obvious sort of inverse myopia going on there if you do that. If you start with the rule of law of a middle level value, then the one which most obviously, most intuitively corresponds to it probably is a fairly thin conception of freedom. You can see why people like Hayek and that whole tradition of a formalistic, thin conception of the rule of law, predictability, etc., the idea, the kind of background idea, you know, that you start with the kind of, you know, premise, the deep political ontology of freedom, you know, and then the law intervenes as little as possible, you know, upon that freedom. That's something which is really quite fundamental to the rule of law tradition. And it's one which has to be overcome. I mean, I agree with Gerry there that that's not sufficient. It doesn't, you know, it in its own terms, it's a very, very thin conception of freedom. It doesn't say what kind of freedom we're talking about. It doesn't say what other sorts of values have to be alongside freedom to make freedom substantive, etc. And what he does is that he takes us in the direction of membership. And this notion of membership is it's a very complicated idea. It doesn't sound complicated, but it is. It's very complicated because it becomes a kind of portmanteau notion which covers freedom both in the negative sense, but also in the non-domination sense. It also covers dignity, equality, and community. So the whole idea here is that the rule of law becomes this kind of, let's say, small c communitarian virtue. It's something which is both about freedom from arbitrary government, but it's also about how that cashes out in terms of a notion of equality, but also a notion of dignity, right? A notion of being taken seriously in reciprocal relations with other people, and also a notion of community, a kind of reflexive notion that you're doing that as a member of a community. So it becomes a really quite strong, and I think in many ways persuasive virtue, but one which has a very, very, I think, a quite significant communitarian bent to it, right? Now, all I would say about that is that if you do that, then you get back into that sort of difficult area, which is to say that if you're moving from middle level theory upstream, then you do move into that dangerous territory of moving from a thinner to a thicker conception of the rule of law. I think that's inevitable, right? And I think Jerry navigates these waters really quite carefully, right? You know, I think he does it in two ways. He does it in the chapter 4 when he's talking about the fundamental principles. He does it there by talking, for example, about the degree of affinity of his conception of the rule of law, perhaps with conceptions of equality, which might have a more substantive material basis than simply the formal equality of the rule of law. He talks about it in the next chapter when he talks about democracy, justice, and fundamental rights as kind of flanking principles, you know, which go alongside the rule of law. And in each of these cases, he says the relationship between rule of law and these other principles is a tendential relationship. It's not a necessary relationship, but it's a tendential relationship. That if the rule of law is going to make sense in the terms that he's talking about it, then there probably has to be quite significant movement in these directions. So there's going to be a communitarian dimension to it. There's going to be a solidaristic dimension to it, which some people would be unhappy with, I think, if they were defending the rule of law. And that's an interesting idea because he's not saying, like, you know, when you think back to some of the debates which you've heard, you know, you think back to the debate over, you know, Fuller's conception of the morality of law, etc., etc. Often these debates would take the form of, you know, that you could imagine situations where, you know, you could have this type of, you know, government which is pathological in a particular way, which was still going along with the rule of law, but these are actually, you know, unlikely hypotheses, etc. I think what Jerry does is he takes it a stage further and says, look, you know, there is something here that there's something about the rule of law, and this is my language, not his, which is it has a kind of generative structure. It has a generative structure. It generates other things alongside it, right? And, you know, occasionally it might mutate in directions where it doesn't generate these particular things, but it actually has these generative pathways where it should actually move in these sorts of directions rather than other directions. And I think that's a really interesting idea and one that we should think about. How long do I have? 2 or 3 minutes? Yeah. Okay, right. Let me say something quickly about the international dimension. I really wanted to talk about the international dimension, but you know, you can't talk about everything. So basically, first of all, I really recommend the chapter. It's really good. It's really interesting, and it gets at a really nice overview of the way in which international law has changed and it's moved, and the way in which, you know, the classical conception of international law as being only about states, as being about a transactional relationship between equal sovereign states, as having no structure of central enforcement, of only being about limited issues. All of these things have gone, right? You know, the international law, transnational law, over the last 60 to 70 years just isn't that. You know, so that sense of international law has gone. Now, despite that, or maybe I shouldn't say despite that, but I think the way that Jerry defends the rule of law in an international context is still very, very much based upon a kind of state-centered view, right? Because most of the virtues of the rule of law that he sees in the international domain are virtues which return to this concept of membership, but it's membership at the state level. He talks about how international norms can promote the integrity of state communities. He talks about how it can promote peace between them. He talks about how it can temper the power of non-state actors and their capacity to infringe upon state actors. Now, all of these things are very, very valuable, but all of them actually play to a sense that the main purpose of transnational law is still, the greater good of the fundamental units of political community, which are the states. And in this case, it's through the rule of law. That's fine, but it's a particular conception, and it's obviously related to how fundamental the notion of membership is to his conception of the rule of law. Finally, at the very, very end, he does talk about the possibility of global community and saying it is possible to think about thicker forms of membership, presumably with their own structure of the rule of law at levels beyond the state. And he says what many people say, and I can't criticize him for it, that this is a matter of degree, right? This is very, very much a matter of degree. I agree with all of that. I think my finishing thought is it is a matter of degree, but many of the things that we talk about as being the virtues associated with the rule of law, dignity, peership, non-arbitrariness, etc., are not themselves obviously matters of degree, okay? So there is a question there about whether a degree of community, can somehow create a degree of the rule of law, or whether a degree of the rule of law is perhaps a contradiction in terms. So I'll leave it there. Thank you.
That's brilliant. Thanks so much, Neil. And I don't know if I heard you right, but or if this was a fortunate slip, but I thought you said instead of generative, gerative, which I like. So a new term to describe your style, Jerry. Cormac.
Thank you very much indeed for the invitation to be here and for the opportunity to read this really rich and wide-ranging book. I really enjoyed reading it. Like Neil, there's a lot written about this, and I felt that there was still something new to find in this book, not least because of the style. Just to endorse those comments about the style as well. You wear your erudition lightly, as Neil said. I think that's true. It's very accessible, but it also illustrates many of its points with interesting analogies, allegories, references to literature, including some of my compatriots, with the closing quote from Samuel Beckett. And also some reference to, I'm embarrassed to say, an Irish poet who I'd not heard of, which is Micheál Ó Siadal. So I had to go and look him up. He has a reference on page 91, so to my eternal shame. I had to look that up. So it really is a lovely read. It's very accessible. It's very easy to read, but that shouldn't detract from the seriousness, I think, of the study and what it's doing. I was also very pleased to hear your opening comments on part of the motivation for writing the book. I mean, I think I also share, and what I'm trying to do now in my own research, expresses this concern about, I'll try and coin a neologism, the sloganization of political values and political virtues, right? This idea that I think Joseph Raz talks about the rule of law being, just descending into a slogan, not him, only him, of course. Jeremy Waldron's talked about this, referencing Judith Shklar. But this idea that if we don't anchor our political values and our political morality in some sense, contestation becomes problematic, right? Because in some ways we all, of course, agree with contestation. It's a good thing, it's democratic, it's all of that stuff that we're kind of brought up to believe, particularly as constitutional lawyers, constitutional theorists, legal theorists. But I think what we've been witnessing over the past kind of 10, 15 years is this kind of abuse, almost abuse of language, but also abuse of value. And this exploitation of contestation for what we might call attempts to aggregate power and abusing value concepts to trample those values and those underpinning ideas. And I think this is really a really important theme. It comes across in the book. And I think, yeah, it's also what I'm trying to do myself at the moment, this idea of getting a sense of getting some sort of a foundation without suppressing the contestation that you want to preserve within that, but at the same time, not allowing it to be a free-for-all, such that you know, different people can claim to be democratic or claim to be Democrats, and that is abuse of the will of the people. Yeah, so my comments relate primarily to the first part of the book, so the conceptual building blocks, chapters 1 through 8. And it's mainly because, as I suggested, this is kind of what I'm working on myself at the moment. And so I thought it was the most useful thing I could contribute to this discussion, some of the issues that I myself had come across, and was curious to hear your thoughts about reflections on the way that you represent and address some of these issues here. So the first part was this idea of membership that Neil has already talked about and that you raised in your opening comments. I had a brief description of it for the audience, but I think it's been mentioned a few times, so I don't think I need to go into it in too much detail. The complex value involving freedom, dignity, equality, and community, which I understood and interpreted as a sophisticated attempt to square this circle between liberty and equality, which we commonly encounter in political theory and political philosophy. Is there a order of priority there? Are they joined together by some even deeper value, possibly dignity? And I understood you as arguing that the rule of law provides an instrumental role in securing these goods of membership you associate with this complex value. And this brought to mind Dworkin's approach to these questions, and particularly his idea of communities of principle. This was in my mind, partly because I'm reading a lot of Dworkin, but also I find that there were a lot of kind of Dworkinian themes coming across in the book, not least the title, of course, From Law's Empire to Law's Rule. But on reading this kind of what Neil characterized as communitarian account, that, you know, it was very difficult for me to shake Dworkin's account of communities of principle, right? You know, with this idea of everyone having equal respect and concern for members, and it grounding many other constitutional goods from that. And you seem to explicitly endorse this when you talk about integrity on pages 94, 95. You don't necessarily relate it back to membership, and you don't mention communities of principle, but my interpretation of what you were saying, there was a strong kind of Dworkinian theme, intentionally or not. So I had a couple of questions out of this. If I've characterized your account of membership correctly, and if it is fair to compare it with Dworkin's account of communities of principle. The first one was kind of an obvious one. Do you see, as Dworkin does, that membership, this ideal membership, creates particular obligations for members of the community along the lines of Dworkin's associative obligations? Of course, this is a big part of his own account of communities of principle, his own account of law. I didn't see that in reading this, particularly this chapter. There's a chapter 4, chapter 5, and so I was curious to find out what you thought about that, about membership of this community. Does it generate obligations for us along those kind of associative obligations lines? Following on from that, again, continuing with the Dworkin theme, does this membership ground political obligation in particular? And of course, this is very relevant to the rule of law. Does it give us an obligation to obey the law, provided that the community we're talking about fulfills this criteria of membership that you've outlined? Quite an ambitious and demanding standard, right? But were we to achieve it, would this give us political obligations to obey the law? And following on from that, I was thinking, does this account, to go back to that point that also Neil made about the kind of demanding standard of community that you raise, is it too demanding? I know this is kind of addressed towards the end of the book as well, but you know, many of the critiques have been made about Dworkin's account is this doesn't represent any community that's possibly ever existed, and it certainly doesn't represent the kinds of communities that I think Dworkin, and perhaps also yourself, have in mind, like the United States as a political community. And part of the way to express this idea is this lovely quote you have from Michael Ignatieff on page 79, which I hadn't come across before, but I shall exploit it with abandon going forward, because I think it's a really lovely idea, especially for pedagogical purposes. So I'll just read it out if that's okay. Again, this is a quote on page 79 from Michael Ignatieff. And he says, "I cannot help thinking that liberal civilization, the rule of laws, not men, of argument in place of force, of compromise in place of violence, runs deeply against the human grain and is only achieved and sustained by the most unremitting struggle against human nature. And I think that injects quite a somber note of realism into this entire enterprise, and indeed our own enterprises, right, as constitutional theorists and legal theorists, and trying to articulate and give substance to and ground these important values. So to take that kind of Ignatieff note of perhaps skepticism, how would you respond to a skeptic saying, you know, okay, yeah, these are nice ideals, your kind of membership is very nice, but which community are you talking about? Because I can't find any community that in any way comes close to achieving these demands, to meeting these demands, not least, of course, in the US. We don't need to talk about voter suppression, gerrymandering, vast wealth inequalities, and many other things, but not just to point the finger at the US. Of course, many of our own communities don't do this either. And in particular, when I was thinking through these thoughts, I was thinking of, I don't know if you're familiar with this, but Suzanne Streeter and Candace Delmas's critique of Dworkin's account in the Boston University Law Review Symposium on Justice for Hedgehogs, where they make precisely this point that, you know, these are nice ideas, maybe they can provide motivations, but you know, where would we see this kind of community emerging, right? And does this create too high a standard to be able to ground the morality of the rule of law and all the other things you want, because that kind of flow from that, and the way that Neil described this meso-level theorizing, you know, moving also upstream to ground these higher values or more fundamental values, depending on which metaphor you want to use, going up or down. So yeah, is this too high a standard to ground the rule of law, given that it is, of course, such a practical concept as well, right, in legal practice. So that was the first set of comments I had just around that idea of membership, overlapping somewhat, I think, with what Neil was talking about. To continue the Dworkinian theme, I wanted to know whether you consider yourself a hedgehog or a fox in this way that Dworkin relies on that essay from Isaiah Berlin. There's a lot in the book. There's a lot of different values and ideas introduced in the book, and they're also brought into a relationship with the rule of law in one way or another. We already mentioned membership, but of course there's discussions there also about the rule of law, justice, democracy, and many others, and this is some that Neil has already mentioned. And so my question on reading all of this was like, okay, so how do we bring these, when moving from chapter to chapter, how do we bring these into a relationship with each other? And what is the thread that kind of follows? And the obvious answer is the rule of law, right? But the idea is, in what way does the rule of law bring these ideas together, right? And so one way to look at it would be, okay, you are, you know, the rule of law is one value among many, right? And that there are trade-offs, especially in chapter 7, when you discuss the normative limits of the rule of law, limitations on law's value. You make the claim on page 140 that, you know, we live in a morally pluralist world, right? And that balancing is necessary to resolve these tensions. I think you even mentioned balancing as a way of managing the potential conflicts in value that we emerge when we talk about these values that gravitate, if we want to use that metaphor, around the rule of law. So this suggested to me that you're Berlin's fox, right? You're a moral pluralist, that you know, there are potentially distinct and potentially incompatible moral values that exist and can come into tension with each other, and that you're not a hedgehog, right? That you're not a moral monist, that even if we can have different expressions and different levels of theorizing about values, that ultimately they're reducible to some sort of a value system, right? That it can be ordered in some way, however we choose to do that. Maybe even reducible to a single overarching master value. And that was, my understanding was that was not what you were trying to do in this book, and that wasn't what you were trying to, or at least that was not your kind of metaethical commitments, if we want to put it like that. But then I wondered, if you're not actually really a hedgehog, notwithstanding these kinds of claims about value pluralism, precisely because there's so much overlap between the different values and the way that you bring them into a relationship with each other, paradigmatically, and I think in this concept of membership that you want to promote, which really tries to bring into a relationship some of the most fundamental values of our moral universe, right? Like liberty and equality in some sense, and make some sort of an arrangement between them. And so the way that you were talking about these values and bring them into a relationship with each other struck me that I started wanting to ask you, if it's not too indiscreet a question, are you really a closeted hedgehog, right? That there's this projection of the moral pluralism, but actually there's a sense on reading this book that you do have some sort of background schema within which all this kind of fits, even if it's not always brought out in the book. So I wanted to kind of press you a little bit on that and see how you would identify yourself along that hedgehog fox division. It doesn't mean necessarily, of course, that we can necessarily identify one overarching master value, that it's like dignity or something else, but more in this kind of Dworkinian, this seminar we were in today, Neil, we were talking about pragmatist morality. The idea of this kind of mutual justification and mutuality is another big theme that comes across in this book, that they're all kind of built on top of each other, and Dworkin talks about the geodesic domes and all these, light breaks evenly across the land, or dawn breaks evenly across the land, all that kind of stuff. So in maybe perhaps a more constructivist, more pragmatic understanding of monism of value, but still a monism of value, right? That in some way, maybe there is a right way to organize and arrange these different ideals and these different values. And maybe even the rule of law allows us to do that, or that the rule of law is a necessary part of organizing that value, our values in that way. So yeah, that was my second question. How would you agree with would you agree with that categorization? Is there a kind of a background schema within which all of this fits ultimately? And I'll stop there. Thanks.
That's great. Thanks so much, Cormac. So Jerry, if you would like to respond, you could. I mean, you've got an existential gauntlet just laid down as to whether or not you're a hedgehog or a fox. So I should probably let you respond to at least that one.
Yes, who am I, huh? Maybe I should respond in reverse order of these questions and see how we can go then, because that's the one that's most present in my mind. I am in my bones a moral pluralist. But I do have, and so I guess, a hedgehog. I'm pretty strongly resistant on general philosophical grounds to the sense that everything is now absorbed into the absolute in some way. The interesting thing here, however, and Cormac, you've picked up on this, is that I have been toying with a philosophical idea for some few years that puts me on the road to more interrelatedness of some values. And so I guess I wish there were some middle critter between hedgehogs and foxes. I don't know what it would be, but the point here is this. You'll see at various points in the book, I draw on this thought that certain values or practices that try to instantiate those values, carry them out. Those values, or certain kinds of forms of motivation, even emotions or passions, can go wrong. They just go wrong in various ways. And they don't go wrong just because they come into conflict with other contending values or values of other passions or emotions. I'm thinking there of pity and compassion, say. But that there's a more internal relationship between some of them. So the discussion of mercy and justice, for example, is meant to draw on that, where the two notions are in the context of punishment and criminal justice. The two notions are not just potentially in conflict, but they are internally related in such ways that the one kind of value or principle goes wrong in just the ways that the other one corrects for or can correct for. Strictly speaking, I need to do really hard philosophical analytical work on this to make it all go. But I've relied on that kind of intuitive idea. And if you go along with me that far, then what you'll see in a couple of places, especially in the mercy and justice equity discussion chapter in particular, but also in the construction of this or value of membership, you'll see that they are not just a combination of values that sometimes coordinate and sometimes conflict, but they are somehow internally related. You need the other one in some way, because just where it goes wrong, the other one comes in there and does something to restrain it. And so that's the kind of thought that goes on. That's different from my discussion of the relationship between the rule of law and support of certain fundamental human rights and the rule of law and democracy. There, what I want to say is there's an interdependence of these values, these important moral political principles. That, and in one case, they seem to overlap in their requirements, but they have different foundations. That's true of democracy and rule of law, for example. Say both of them require very stringent defenses of freedom of the press, association, things like that. But they are also interdependent in the sense that you can't get one very far without depending on the other. And it's a kind of mutuality. And yet they can conflict in just the way we used to think about obligations being overridden by other obligations, an old-fashioned Rossian view. So not everything fits together in this neat, mutually limiting arrangement. I just think some of them are signally so. And that's especially important to identify when we are faced with the question of what do we do when they seem to be in conflict. Balancing seems to be the wrong metaphor, the wrong strategy. So I want to be a middle-level guy here, animal. I'm not a grand, all swept up into the absolute, nor am I a kind of very particularist or even kind of second-level particularist with respect to the universe of plural universe of values. Some of them fit together, maybe, right? So I'm hoping that will, in further work of mine as time goes on, get fleshed out. But that's the thought.
Can I just sorry, just say to exercise the concern. So with mutuality and interdependence and so on, my suspicion always with that is where does it stop, right? Yeah. You know, how do we know when to stop? And in a non-arbitrary way, obviously, yeah. Right? Yeah. And so I find it hard to get out of this sense of inexorability of, you know, Dworkin's unity of value, you know?
Yeah, well, I mean, some of us are more moved in that direction than others. Some of them find it harder to resist than others, right?
Sure, yeah.
And I understand that. But nevertheless, I think that we can't just simply say, well, a criterion of success of all this is that it fit into one single framework. Maybe, but I'm not going to force the depth of our understanding into a framework that is as abstract and really totalitarian in a way that I think would be unhelpful from a philosophical point of view, let alone from a normative point of view. Let me jump to a comment by Neil for a moment. I like the idea of a generative structure. Neil. there is a sense, I mean, I have read at least one review that hasn't yet been published that says Postema's a rule of law maximalist, because all of his objections or reservations notwithstanding, he's going to build in democracy and human rights and justice, all of those, and it's going to sound like a kind of agenda for left-wing imposition of the rule of law on everyone outside of the United States, or at least New York, right? And I don't like that idea. I do think that the very reason for distinguishing between these different components of a conception, where our disagreements can be going on at quite different levels, allows us to say, well, thicker where? If you're saying thicker in terms of the concept of the rule of law, by no means. I'm perfectly willing to say, and say often, that the rule of law can obtain in a community and it still can be massively unjust. That's not a failure of our concept that it hasn't included justice in it. But I do go on to say at some points, if it turns out that certain kinds of social infrastructure is necessary for a robust rule of law to take root in a society, then we might want to think that those elements, maybe they are concerns about the vast inequalities of wealth, say, those concerns will be relevant rule of law concerns, because we think the rule of law is important and we can't discipline power over people when these social conditions are such that the very sources of the spirit of that rule of law and its use in a community are undermined by the very social conditions of that sort. I'm not making that argument, but I can see how that argument would be relevant. That doesn't make economic distribution a part of the concept of the rule of law. It has to do with what are the underlying social conditions we need in order for the rule of law to be robust in a community, given that we understand it to have these elements.
Yeah, can I very quickly just come in? I agree with that. I mean, obviously, I should have drawn a distinction between causal dependencies, etc. You know, which is what you're talking about, and a kind of, which takes us back to a previous conversation, a kind of moral suggestiveness. You know, I think there's also a moral suggestiveness there as well. The way that you talk about membership and its relationship to notions like solidarity, etc., etc. That's not about causal relationships. That's
No.
That's about it being a kind of cluster concept, you know. So I think that's in there as well somewhere. Yeah,
I thoroughly agree, and part of why I wanted to go beyond individual liberty and beyond dignity is that there is something more that's, I think, crucial for understanding how those elements are together supporting the kind of demands that the rule of law seems to want to put in place. And so I'm trying to construct at that, upstream level, trying to construct a view of what's really important that's compelling.
Yeah.
And it's got to be compelling in a way that's not so narrow that it excludes a lot of other things that are compelling, while at the same time not being arbitrarily a collection, right? So it's got to be suggestive because I want it to be compelling. It's got to be broad enough so it brings into focus a number of what might otherwise be thought to be different concerns. If they are intimately connected and we can explain that, then I would think that's perfectly okay. Though that background moral foundation isn't the core of the rule of law. The background supports the kind of claims the rule of law makes. It's the foundation. If you want to disagree about that, don't say it's too thick because it's really morally thick. Well, yes, of course it's got to be. That's the function of it. That's the task it's got. But it's not the concept of the, or even the core, normative core of the rule of law. The normative core gets it, the rule of law gets its core because it's in service of that. Now, okay. Am I a Dworkinian, Cormac? Well, truth be told, of course, I sat at Ronnie's feet for a while in Oxford. And there's a good bit of the way I think about law that anyone who wants to do an intellectual biography, forgive me for hoping no one does, will say that sounds a whole lot like what you learned from Ronnie way back. About the communities of principle generating obligations alike, let me say just a couple of things about that. One is, notice that the idea of membership is itself a moral ideal. It's not a description of any particular community, or even any particular community that sort of approximates it. It's meant as a moral ideal. Now, it's a complicated one, of course, but it's a moral ideal. Now, part of that moral ideal is the thought that there are shared responsibilities and attached obligations. Now, how does that fit with the communities that you and I are familiar with, whether they be in the United States or in Scotland or in France or in Namibia, right? The question is, how does that work? And the answer is, well, of course, none of them match that ideal. And there's nothing in this account of membership that says if you get a bunch of people together, they're going to generate membership. They're going to generate obligation. So that's not the thought. It's rather that this ideal is one a community can strive for, where it's a community in which the obligations are shared. It's the idea, it's an ideal, I call it a mode of association. It's an ideal for our association, an ideal worth striving for, not necessarily instantiated anywhere. And it doesn't follow from the fact that we are stuck together that we actually have that or even approximate it. Now, this gets me to a point that Neil was asking about international law, and then maybe I can stop. Keep in mind that the idea of membership does take really seriously the way in which individual human beings are enriched by the community in which they find themselves when it meets the ideal of membership. And that the international law, when it meets conditions of the rule of law, can be justified if it serves adequately the ideal of membership at two levels. But the more important one is the political community level. So what I say in that chapter, if I can recall, is that one task of the rule of law at the international level is to enable, equip, empower those structures at the transnational level that uphold, make possible such communities. And then it serves the interests of the members of it. Now, there is also the question whether we can talk about membership at the global level, right? And that's if Cormac thinks it's a problem at the political community level, it's a much bigger problem, of course, at the transnational level. And there I say, well, we don't have to have really thick notion here of membership even there, or of community. but maybe we don't have it. Maybe we don't have it at all. Is it something worth striving for? Perhaps. So that's the way it works at different levels. There's really the foundational one, and then the question about whether there's any community plausibly considered possible at the international.
Brilliant. Thanks so much, Jerry. I'm conscious of the time, and we have 2 more commentators. What I will propose is that we just have a short 2-minute break. Just, I think it helps to have just to be able to stretch one's leg for 2 minutes. Just before we do, I can't help but say, and I don't mean to be flippant, that I couldn't help but think of one possible critter or creature which appears in the classical and in some of the early modern sources, and which can be a kind of icon for balancing multiple levels, different relations of values. It has in part the circumstantial, particularistic cunning of the fox, and in part the seriousness of the hedgehog, and that's the octopus.
Octopus. Yes. Furthermore, it has 8 legs, right?
Right.
Very good. I love it. I'm going to make a note of that.
Great. Let's have a break for a minute or so, and then come back. Thanks. Great. Well, welcome back, everybody. So we have 2 commentators in this panel, Nicole Roughan and Hans Lindahl. I must admit that my guilt is somewhat eased, Nicole, by the fact that now you do have at least sunshine and light in your room, so that it's not too early. Would you mind going first? There's been a suggestion from Hansa that perhaps he could invite you to speak first. Does that sound okay?
Yep, that's fine. I'll just swallow my breakfast. My 1-minute breakfast. Oh, that's very kind of you, Hans. Perhaps he was worried I would be running out of things to talk about with the rich comments we've already heard. This, obviously echoing everybody else's praise for this book, but one way of expressing this is that the book was sitting on my dining table, and my father-in-law, who's a disaster scientist and engineer who's been kept very busy in New Zealand recently, picked it up and started reading the chapters about digital overlords, and also the chapter on AI, and immediately said, "I'm borrowing this, I'm taking it with me." I said, no, you're not. I need it for 1 more week and then you can borrow it. But he was absolutely gripped and hooked, and was going to go off and recommend it to everybody, because I think he saw that the challenges being discussed there were challenges that are faced not only for those of us who work with law deliberately, but for those who have to work around law when they use the expertise that they have. I shouldn't say work around law in a cagey, cunning fox-like way, but actually who have to, of course, use law in their various fields. So I have a couple of big ideas, and I'm hoping I'm going to be able to get through both of them. One of them is to really talk to Jerry and perhaps ask for a bit more from Jerry about the role of the subject here. And Jerry's work has been a rich source of inspiration to me for a long time, and I come back again and again to his work on the persons that we find in the law, and of course law's subjects being some of the most important. And one of the concerns I have about this quite horizontal, richly sort of mutual ideal that he's including within the idea of membership, as well as including within the ethos of fidelity, flattens out some of the responsibilities so much that we risk losing the very central dynamic of power over and power received. So there is a concern, I think, or I had the concern reading about how many of these responsibilities and how many of the demands and requirements that we all commit to holding one another accountable, holding power accountable, sharing in an ethos of fidelity and so on, might risk us losing sight of the sort of uneven vulnerabilities that people have to one another's power. And this, of course, is something that Jerry has written about in so much of his other work, where he has explored the roles of sort of public officials and their own need to commit to accountability and so on, and then has elevated the perspective of the subject in trying to explain how the rule of law, or I suppose why the rule of law is required. And I felt that in this particular iteration of it, because there is such a rich emphasis on the sharing of responsibilities and such a rich horizontal story of membership and a rich horizontal story elsewhere about fidelity, I think we risk that the subject gets a little bit lost. I mean the subject as person. I mean, yes, it's true that those who wield law's powers are also law subjects, and that comes through very clearly. But the most vulnerable person here is no longer the sort of star of the story. Instead, that person, that most vulnerable person, and I guess groups of most vulnerable persons too, are also themselves, deeply burdened, right, with this responsibility. So I guess I was looking for a little more differentiation, or asking indeed whether the differentiation of the shared responsibilities is still important in this account, or whether in the ideals that we are hearing about, there is something something of a shift away from that focus. Perhaps that's a focus that I've always read into your work, and so I just expected it to be there front and center. But it's certainly one of the focal points that I've always, very, very helpfully drawn from what you've said. And I think part of that is actually packaged within an idea of the public itself, where the idea of the public is not simply about something that is general, common, shared, and so on, but is also something that is differentiated. It's very hard to understand the idea of the public, I think, without having a sense of the differentiated roles that constitute that sort of phenomenon, where the role of the subject or the citizen, if you must, or the person who receives most of the power, I mean, who is the recipient of the power wielded over them, and then on the other hand, the persons who are exercising and wielding public power, or power in the public domain. So that's the first point, and I think it's a smaller point, but it's related to a second concern, which is about the role of claiming to use or claiming to operate the rule of law. Jerry in the book has in a number of places, and I'm sorry I didn't note page references and things for people, but these really are scattered throughout the book. But there are a number of places where we hear about public officials and others who wield power needing to commit to the rule of law, needing to hold themselves accountable. And it does sound as though that kind of commitment, or that kind of claiming of acting through the rule of law needs to be not only in fact reflective, right? They need it, that involves people holding themselves or seeing themselves as having to work through law, but is also sort of a holding out of that commitment. So it's being presented. So it is a public commitment, perhaps, or it is at least something that people can be expected to be aware of, right? So when people are committed to the rule of law, when public officials are committed to the rule of law, they are publicly so committed, right? And I suppose part of the question is that right? I mean, does it matter that it is an obvious commitment? Because I think this folds into the concern that when public officials are claiming to be committed to the law, rather committed to the rule of law, are claiming to be exclusively wielding powers through law and not through other means, that subjects need to be able to hear that claim. That is, they need to be able to receive it. And so part of emphasizing the subject side of the story, I think, would involve fleshing out more about what it means and what subjects hear, right? When public officials or power wielders are so committed. this, I think, comes, it comes in a little bit in the discussion of membership, where there is the thought that persons are, a person's obligations are, of course, owed to one another, but they are owed as part of a shared kind of project of rule of law support and rule of law commitment that they're all aware of, right? That they somehow are participating in, right? Perhaps more actively in some cases and more passively in other cases, but there is at least an awareness that there are rule of law commitments and that this is something that that persons can recognise, persons subject in a community can recognise, and that seems to be quite a demanding sort of requirement, right? It's quite a lot to demand of subjects, that they are sufficiently aware of the commitments that their officials are making to the rule of law. But more interestingly, I think it's quite, or perhaps more problematically, it shapes, I think, what the public power wielders themselves need to be doing. That is, if they're holding themselves out as working through law, then they need to be cognizant of how the subjects will be receiving that. Now, both of those, I just want to, I perhaps should have given these comments in reverse order, because I'm about to say something which I think might illustrate the concern, and I perhaps should have started there. But I was really struck in the discussion around the sort of early setting up of the key concepts, that you land right at the end of that chapter on a brief discussion of alienation and I guess what happens when persons are rejecting, the community, or rejecting the claims of the rule of law and so on that they are being confronted with. And this is just a short discussion, and as you rightly note, and it's a large phenomenon and really takes more dedicated attention than you can give it in that early chapter. But this idea of alienation, or this problem of alienation, does seem to be a case where you have something of a mismatch, right? Where even if you have public officials with the best will in the world, seeing themselves as governing through law, being reflexive and having institutions and systems to hold themselves to account, you might still have alienated citizens / members / those subject to the power in that community who reject that, or who don't recognize that in fact law or law's rule is being used to govern them, rather than just mere or arbitrary power or something else. And the most striking context of this is, of course, context of the imposition of membership itself, or the imposition of a foreign legal order. And you mentioned briefly the colonial context, where you might end up with situations of sort of legal pluralism, where you have what you refer to as some of the more customary or informal norms that continue to operate, where the imposed foreign legal or colonial legal order isn't fully deeply rooted, or doesn't become fully deeply rooted. And that strikes me as one of these really paradigmatic cases, where you have a mismatch and a disjuncture between what is claimed to be law's rule and what is experienced as law's rule, where a pre-existing or a prevailing, perhaps pre-existing and then prevailing different legal system or different legal order disrupts the recognition of the imposed legal order. And you point to this as a situation where you could have as a situation which doesn't so much cause problems for the rule of law or for law's rule itself, but openness to the possibility of having rule of a different law, right? So that we can then look not at the rule of the imposed order, but we can look at the rule of the informal legal order, or the pre-existing or prevailing. Those are my words, not yours. But whereas really what I think goes on in that context is a generation of this sort of alienation concern, and this mismatch between the claim to law's rule and the receipt of law's rule. Because, and not to generalize, because every colonial and then post-colonial or continuing colonial situation is different, but I think you very often have then the operation of genuine plurality, where you have multiple claims to these legal orders ongoing, which generates the question whether law can rule over that relationship. And that is a genuine problem of whether you can apply sort of the conceptual toolkit that you've given us to think about the rule of law, and then say, okay, if you have structural plurality, let's say, where you have engagements between legal orders that are both being claimed and recognized in the same place, you then take your rule of law conceptual kit and elevate it to say, well, okay, that relationship itself between those legal orders must be the one that we rule through law. And so then we've taken ourselves a level up, I suppose, in the analysis. So there's a sort of a string of concerns there. One is that when we look at those subjects and we re-elevate the conception of the subjects, we worry about what they receive when they hear claims to law's rule. And then these become particularly acute challenges whenever there are questions of alienation, which very often are well grounded and well justified in terms of the political memory of a community, which might include experiences of colonization. But I think there are probably other deep and long running concerns that can generate these very, very, I think, well grounded alienation questions. But then also we can see that in some cases there is this additional structural problem of plurality of claims to law's rule and claims to the recognition and receipt or respect of law's rule by subjects, which then just, I guess, prompts this sort of meta question about whether we then can shift our focus or shift our target away from thinking about law's rule in a single membership community, richly conceived, or perhaps more or less richly or thickly or thinly conceived, as you just explained, through the idea of membership, and then look at relating communities to one another, and relating, overlapping, but yet still in some ways distinctive membership communities to one another. That has some echoes, I suppose, with going back to where Neil started us off and thinking about community and membership in international law. But I think the particular continuing colonial / post-colonial context adds a different, perhaps, range of challenges there. Max, I have no idea how long that was. I'm sorry if I've gone over, but that's the gist of what I wanted to ask.
That's perfect, Nicole. Thanks so much. Hans.
So thanks so much for the invitation to comment on Jerry's great book. I must confess that I'd already sent an email to Jerry about what I would be commenting on, if nothing else, because I come from not from an Anglo-Saxon tradition or Anglo-American tradition in legal philosophy, but a much more continental tradition, phenomenology, and, well, to a certain extent also analytical in terms of collective action theory. And so my comments are actually resonate a great deal with Nicole's comments, which is perhaps not strange at all, Nicole. Jerry commented at the beginning of his presentation this evening that part of what he was interested in was challenges to the rule of law. And it seems to me that he's offered a very rich and, I think, nuanced analysis of when there are serious challenges to the rule of law. It seems to me that this issue appears at least on 4 different occasions in the book. First, when he discusses a diverse membership within a community, and in particular, the distinction between oneness and wholeness. And there again, the music, he draws a distinction between e pluribus fugus and pluribus unum, and argues for e pluribus fugus rather than e pluribus unum. I'll come back to this later. I wonder if at the end of the day, or let me put it another way, how far you can actually take e pluribus fugus before it becomes e pluribus unum. But having said that, that's one first aspect of challenges to the rule of law, which Jerry engages with. A second one, which he would probably want to distinguish it from challenges, is, of course, threats to the rule of law, which concern norm infringers, entrepreneurs, and saboteurs of the rule of law. A third engagement with challenges to the rule of law is, I think, the problematic of dissent, and that in the form of civilian resistance, which, if I understand Jerry correctly, ends up spilling over into issues of civil disobedience. And finally, of course, and perhaps most starkly, the problematic of the exception, and for which, of course, Schmidt's account of the Ausnahme is perhaps paradigmatic. Now, my own entry into issues of the rule of law is also the problem of the challenges to the rule of law in a way that I think speaks to each one of these four dimensions that Jerry has been commenting. If I try to summarize it, it's in terms of, can we still make sense of the normativity of the law? In terms of what Jerry called today its normative force. In those situations in which force and normativity can no longer be held together from the position of those who are the addressees of the law. And when, to borrow Nicole's expression, there would be perhaps excellent reasons to not accept the normativity of the law. And she was referring, of course, to situations of coloniality. Can we still, in some way or another, assign some form of normativity to the rule of law? Therefore, those individuals or for those groups for whom the rule of law is the rule of force. To put it another way, at stake here is, I think, indeed the problem of membership and community, which Jerry referred to, and of course is richly developed in his book, and the problematic of inclusion. That is to say, what about those cases in which what is at stake is not securing inclusion into a community, but rather where inclusion is itself the problem? To put it yet another way, to refer to, on a riff on Hannah Arendt's famous "The Right to Have Rights," what about those situations in which what is being claimed is a right not to have rights? And what I have in mind here, and I passed on an article to Jerry about this, is a combination or a sort of cross-cutting reading between the Aboriginal tent embassy on the lawns of Canberra, in front, or rather in Canberra on the front of the lawns of Old Parliament House on the one hand, and the Mabo II ruling of the Australian High Court. Back in the 1970s, a small group of Aboriginals pitched a tent on the lawns of Old Parliament House, saying, look, if we are going to be treated as aliens in our own country, and they would speak of Ruwe, they would not speak of territory, then of course we have to have an embassy. Now, what was interesting in that situation is that there was no ordinance that prohibited pitching a tent on the lawns of Old Canberra, of Old Parliament House. And so it was an incredibly embarrassing situation for the government, the McMahon government. And they ultimately evicted the tent embassy. They have returned, and the tent embassy is there now. And what that tent embassy is now demanding is not simply additional land rights. They demand sovereignty. What they're saying is, you have colonized us. This is, your rule of law is basically force. It's violence, it's institutionalized violence. It's not the rule of law. So if you read the Mabo II ruling of the High Court in the lens of this contemporary understanding of what the tent embassy is about, it becomes clear, and if allow me to use the chat function to refer here to the key text of the key passage of the Mabo II ruling. What it says is, recognition of the radical title of the crown is quite consistent with recognition of native title to land. And of course, what was at stake here was repealing the infamous terra nullius doctrine, which had been sustained consistently by the High Court and all other judges within the Australian legal system. Now, of course, the whole problem from the perspective of Aboriginals that demand sovereignty is that this argument is circular, because of what the court is arguing here is that native title to land can be recognized as such within the framework of the Australian legal order. So that what the court does is say, look, yes, we apologize. We have not treated you as full-fledged Australians, and we ought to do that. And in the very best of cases, what the court could have said is, we are prepared to ensure that you have not merely formal rights that would render you formally equal to the rest of Australians, but that also materially speaking, you are fully fledged Australians. But of course, from the perspective of the Aboriginals that demand sovereignty because they've been colonized, equality is precisely what they don't want. They don't want to be treated as part of the Australian society. They resist it. They want basically to recover and reclaim Rue as their traditional lands. And so their argument would be that the very notion of radical title, which is of course a notion of common law, is an oxymoron. Because if it is to be a title, then it cannot be radical. It has to proceed from earlier law. But whatever might have made it law was simply the brute fact of colonization, might. And if it is to be if it's to be radical, then it cannot be a title, at least not a legal title. So what you get here is, I think, a kind of gridlock, where you get a situation where, from the perspective of the Aboriginals, speaking about law's rule is to speak ultimately about law's might, that is to say, to collapse right into might. And my interest here is not to be cynical about the law at all. My question here is there a way of trying to make sense of at least a residual normativity that would allow a legal order to, in one way or another, acknowledge, at least indirectly, its violent origins, at least in cases of colonization, in a way that would, in some way or another, try to at least, well, I don't even think that mitigate is the right word, because even if you speak about mitigation, then you cannot say simply that it is a rule of law in anything like a rich sense. So my question to Jerry is as much a question I'm raising about that of my own perplexity about these kinds of situations. How do you deal with those situations in which reciprocity is not what takes us beyond domination, because reciprocal recognition as mutual and free citizens of a collective is precisely a form of domination for those who don't want to be citizens, viewed as equal and free members of that collective. But having said that, it's a question that I have no answer for yet. And I was very curious to see if perhaps Jerry could help me out of my own puzzlement. So thanks.
That's great. Thanks so much, Hans. So Jerry, would you like an opportunity to respond?
Yes, what wonderful comments, really wonderful comments. It's always what one hopes for in symposia like this, that you don't just correct confusions after you've heard them articulated again and again, but you actually, the author, gets pressed to think deeper and harder. Both of these questions do that. Earlier questions, comments did it as well. And I must say, sorry, Hans, but I'm not going to get you out of your puzzlement. And I don't even quite know how to approach it yet. I'm inclined to think that what we have here is a challenge at really the foundations of the rule of law as I understand them. That is this idea of membership. And the limit to that moral normative notion, or complex one. It does take inclusion very seriously. It does take equality, peership very seriously. And it values relationships, interrelationships within the community so highly that it may just be blind to the kind of claims that the tent embassy people were making. It worries me then, which worries me in the sense that I want to think a good bit more about that. I always thought that when people, we've heard this objection often, when people talk about community, or I would like to talk about membership, it sounds like we're talking about inclusion, but of course, community always has boundaries, which means that community always excludes as well as includes. And I'm very sensitive to that dimension. But I thought of that in terms of the exclusion being undesirable, a burden, a loss, a harm, not as a desired outcome. And so I always thought about the inclusion part of it as trying to find a place for the difference, the diversity within a community that nevertheless sees it as a kind of unit. Hence the refusal to e pluribus unum, and the thought that on a musical analogy, we can think of counterpoint as having these different, even conflicting elements that in some way still could be part of a coherent, in that case musically, but we might think morally and socially coherent a unit without necessarily a unity, right? What you're pressing me on, and I find it just fascinating, is, well, sometimes we don't want to be a part of that counterpoint, right? And your attempt to bring us in on supposed legal grounds that are supposed to bind us as well as you, that comes across not as uniting us under a common set of laws, but in fact dominating us. Is that, I think that's sort of what you're saying.
Yeah.
And that's also a problem for rule of law, or for law as these judges were attempting to articulate it. One might think trying to be honest to convictions with regards to the rule of law. They were blind to the way in which doing this actually is taken up by these tent embassy people representing the people as an imposition. It's sort of like Christian missionaries going off and saying, you know, we're going to give you this benefit, but what they're doing is they're imposing, eliminating one kind of focus for the lives of those they're addressing, and substituting for it another which they take to be a better one. Right? So I'm just saying what you're saying, I think, if I can capture it well. And I think it really brings to my mind that there are limits not only to the rule of law, but there are limits to membership.
Yeah.
And it's ideal for us. And if I can revert back to my comments to Cormac before, that shouldn't be disturbing to me, surprising to me, because I don't think membership is the only important moral political value. There are others. However, that's a little bit too quick, because one of the key components of membership was non-domination. And it looks like what you're pulling out is a way in which that very motivation looks like it's domination itself. So maybe a way into this is to think about forms of domination that I haven't yet taken into account.
Yeah. Thanks so much. Just to make my own perplexity even greater. I mean, one obvious institutional way of dealing with this would be secession.
Yeah,
And of
right.
course, if Brexit shows anything, it's of course that in the very process of secession, you're incurring exactly in the same dynamic of claiming to be a distinct community that wants to secede from Australia, for example. Certainly, those very indigenous peoples would probably, in the process of claiming to represent an indigenous group and an indigenous unity, there will be people within that community will say, "Count me out. I prefer to be a part of Australia."
Yeah.
So
yeah.
that's what makes it especially fraught as a normative problem. That if it were as simple as simply engaging in secession, well then, we probably it could be dealt with, and also normatively, but it becomes even more complicated because of the dynamics involved in the representation of collectives and of membership.
Yeah. So many levels of worry there, some of them being internal to the group, that the dominant thought, hope being secession or sovereignty or standing outside, while yet it's not a unanimous view. And so there will be, may well be people within it, proper members of that subgroup, who will not want to be. It's curious. Those are much more serious questions, but there's also a movement now in the state of Oregon. The people in the East want to join
Idaho.
Yeah. And because the western part of the state is far too blue, far too left leaning. And of course, there might be a majority support for that. Actually, the United States faced this a century and a half ago, and fought a civil war. So what that suggests to me is that there are some key questions of the internal, how to understand those internal principles that generate the normativity. But I'm also inclined to say that sometimes you might want to say, secession is really a bad thing until it's not. That there are likely to be times when it's conceivable that secession, or on the other hand, revolution, is the only way we can achieve something that's really important to achieve. Costs being what they are. I don't think we're going to go that far yet. I think in some ways that's just too simple. But that's on the horizon too. Thank you for a question that just will puzzle me for a while.
Thank you.
Nicole, wow. The role of the subject, take it we mean, you and I, the individual member of a community, who is, as Kristen Rundle helped me see, not subject to the law, but a subject of the law. That is, a subject in the workings of the law. That's what we want to think about. And as a member, not an element of the set of people in a community, but a member with others of that community. And the question is, well, there were I heard several questions, challenges really, important ones to think about this more. The rule of law recognizes that asymmetrical power relations are an inevitable part of social life forever. And in fact, what its premise is, since they're inevitable, we need to have some way of disciplining and managing it, not eliminating it. It's not eliminable. And so the first step, you might want to say, this is making the Hobbesian leap. The first step is to introduce a regime of law. But of course, to introduce a regime of law is to introduce lawmakers, lawgivers, law enforcers, which then adds a new question about who's going to guard the guardians. And so we've got now a much more complex story. But the answer to the inevitable asymmetries of power is not to eliminate them, but to find some way of disciplining them. And because we're talking about the rule of law and not other things, I mean, the exercise of ancestral relations or appeal to religion or whatever. There are various ways in which we might manage that. The rule of law says, let's do it. Here's one way, let's do it via law, okay? So it doesn't try to eliminate them. Nevertheless, you're quite right that we are concerned all along about the continuing status of the subject. Sometimes that subject's going to be the object of the exercise of power, the one that's over whom power is exercised. Sometimes they'll be in a position of exercising power over someone else. But you raise a really interesting question. To put it in my language, I hope it comes close to what you had in mind. Look, Fidelity puts pretty serious demands. I mean, in a way that my account, I think, does more than any other account of the rule of law that I've seen. It puts demands on ordinary folk. Is generally recognized that the rule of law puts demands on governing powers. I want to argue not only public government, but also private governing powers. But we understand that part, but it also, because I think you can't get the rule of law off the ground in any way possible without thinking about the ethos that underwrites it. If there's anything that I think is sort of new, is the idea that this ethos is not just a social precondition, but a normative one. Fidelity is a set of responsibilities, not a set of attitudes, set of responsibilities. But what you're saying here is, okay, but what about the poor schmuck that's got to do this stuff, right? That's got to get together with others. I'm mindful of the burdens now that you've brought them to my attention. What does seem to me true is that the burdens are more or less onerous depending on the other social conditions. To put that burden on someone who is a single parent dealing with 4 kids, one of whom is disabled, living on an economic margin, the burden is enormous, right? And perhaps what we need to say is those burdens have to be modulated relative to the capacities that these subjects have. But the other side of it is that I think of these responsibilities as not just burdens, but empowerments, a role to play. So they're not just victims of the power that someone else, that they have to rely on someone else to protect them from or to exercise accountability in their behalf, but it also is empowering in the sense that they've got a role to play. That doesn't lessen the burden so much, but it puts it in a different, morally different light. About the mismatch and alienation and pluralism, legal pluralism, I wanted to gesture towards that whole area. I confess, it seems to me beyond my full grasp. And in some sense, the talk about alienation and the like was meant sub rosa to be an invitation to people like you and a lot of others to think about this issue in the context of the rule of law. And I'll join you, right? But I think those are really, really important questions. I had been thinking about alienation and the like as you can tell from various examples in the book, about American experience, especially American racial experience, inheriting, imposing, legally upholding slavery for so long, and then all the aftermath of that, such that there's a whole population that are in various ways alienated reasonably because they don't see any purchase for them under this legal system. That's different from the colonial one, though analogous in some ways. The colonial one is a little different. Of course, we have colonialism in the United States too with our native populations, and that brings it closer to home for me. But I think you've identified, again, like Hans, a brace of issues that I think we can profitably think about really much more seriously. And I hope that the structure of the conception that I tried to put together locates this not as a problem about what's the concept of the rule of law, but really has to do with how do we usefully, responsibly incorporate commitment to the rule of law, given these conditions under which they will have to be lived through and built on. That's only a touch, I'm afraid.
Thanks so much, Jerry. I'm conscious of the time. We have reached our allotted 2 hours. I mean, I feel we could keep going forever. I'm also aware that we've not given the opportunity to audience members to ask. So, I mean, if I can ask for your indulgence just for a few more minutes, then why don't we gather a couple of questions? I see one from Letitia, so do put your hand up if you'd like to, and I'll just gather a few, Jerry. Hopefully, that will be helpful for you to hear, and then see if we can give you the last word. So, Letitia, please go ahead.
Thank you. Thanks so much for this fascinating conversation. I think it's just a pleasure to be here at night and listening to such bright minds. I think my comment connects very well with what Nicole raised as a concern. And I understood Nicole's comment to be more in the direction of your horizontal way to understand the rule of law. And I think I had already a comment without having read the book, but for sure tomorrow I'm going to read the section on public international law. I'm myself a public international lawyer, so I have nothing to do with philosophy or political morality, but certainly I do take an interest in those concepts. So I'm curious about your view on whether your concept of law embeds an idea of public or perhaps publicness, and whether your concept can extend to an idea where private entities exercise some public authority. So I think the concern is there because of the subordination of the private to the public. I think in your response to Nicole, you mentioned private entities, and I think you glanced on the transnational context in which your concept of the rule of law may operate. And perhaps a second comment is there a particular reason for which you understand a community or membership based on values and not on interest, in this case, perhaps public interest that binds together a community? Thank you.
Just before we, Jerry, you would respond, are there any other questions? Let me just very quickly throw one in myself, if I may, Jerry. You've heard from Hans and Nicole about the reluctant participant. But I wondered myself about the enthusiast about fidelity. Now, that is one figure that you do. So an enthusiastic participant in these practices of mutual accountability. You do talk at various times about the possibility of abuse. And you say you want to temper, this fidelity would need to be tempered with decency, compassion, mercy. I wondered, however, whether that reaches deep enough into the problem of the kind of community that would arise if we're all sort of participants in this practice of mutual accountability, because what kind of community would it create? A kind of community of mutual surveillance, but not just that, of where one comes as a participant into a community from a certain position of normative security, almost, where one is committed to certain ideals and sees others in light of them and judges others in light of them. I worry about the kind of attitude, interpersonal attitude, that this kind of your ideal member, your ideal participant in this ethos would bring, and what kind of community this would create. Perhaps you could just speak to that concern a little bit more.
Sure. Leticia, let me respond first to your questions. I spend a little bit of time explaining what features of law are important for the rule of law. I talk about it in the relevant chapter as those tools in the law's toolbox. Publicness is a crucial component of that. Law is, I don't want to say by its nature or by its concept, but a really salient feature of law is that it is out in the public, for the public, governing the public, in the sense that it's governing individuals who are nevertheless grouped together put together into groups, and the law operates well when it addresses the interactions amongst those participants in that group or community. It's public in that sense. Publicness also plays a crucial role in the sense of publicity. That is, its operations and the operations of those who exercise power must be transparent, available, accessible, assessable, right, and that sort of thing. There is one. I'm not sure exactly if this was your concern, but there is one feature of my account that might be taken by some defenders of the rule of law to be highly controversial. And that's the claim that the rule of law is concerned with arbitrary exercise of power wherever it happens. Now, there might be times when law shouldn't get involved, but wherever it happens means it's not just focused on the abuse of power of the state or public entities. It's also concerned with the abuse of power wherever we find it in our political communities, and that may well be by private corporations, employers, and the like. So the private public doesn't figure in as an important distinction with respect to the kinds of concerns that lie at the heart of the rule of law. I go on later to say we have to then think about where law has the capacity to do a good job of constraining those of exercises of power, possibly arbitrary ones, and where it would not be particularly useful, and where, even if it were capable of doing it, where the intervention would be too costly. So that's in response to what I took to be your question, but I'm sure there was much more to it than that. The other question had to do with why community based on value rather than interest. And I guess interest is a thin basis, and it's sort of occasional or contingent, and commitments with respect to value are more deep going. I think that community, if we can think about it at all in the context of transnational relations, we're more likely to find community of interest. And I argue this in that last chapter, that we're more likely to find an overlap of interest than the overlap of value. And that's not a bad thing. Maybe all we can hope for with community in the transnational domain is a community of interest with regard to certain kinds of things, obviously peace and security and the like. Okay, there's more to say about that too, and it's looking for community of value, or doesn't mean a community thickly, richly interlaced with a whole bunch of values. It's just a few that actually can bind us together. So I'm thinking of relatively thin rather than thick and rich relationships, as a friendship might be, or a family might be. Okay. Max, yeah, I gave a paper, a version of this in Oxford some years ago, I don't know, maybe 5, 6, 7, 8 years ago. And I think someone there, and I'm just escapes me now, who that might be, who charged that this is a recipe for a community of scolds. Isn't this going to be a community of scolds where everyone is looking in on everyone else's business and the like? And as I want to say, taking the responsibility of holding others accountable seriously has its limits, has its moral limits, and it can easily be deformed into scoldism. And so we must think about the nature and the scope of our responsibility and how we carry them out in terms of whether it's really advancing the concerns of the rule of law, consistent with this deeper commitment to membership values, or whether it just carries off some individual project of one's own to master another neighbor, or in the famous debate, the Hart-Fuller debate, wasn't it, about the Nazi woman who turns in her husband, right? Those we can, I mean, they're easy examples, right? We can eliminate them because they really are not in the service of the underlying values. But in the end, when we're thinking about whether these activities and responsibilities have limits, we have to think about whether they well serve the underlying values of the rule of law and membership. And even when they do, whether they are constrained by other important moral concerns. That's where we draw. As I say, I don't draw any bright line. I just want to shed a light on it. You've helped me shed light on this one.
Thanks so much. And I really appreciated in the book how deeply you were thinking about the social texture of the rule of law. I think we have reached time. I think some people have put questions in the chat. Thanks so much for doing that. I will copy and paste those to make sure that Jerry can see them.
I see it.
Yeah. But just to make sure that some of us can go have dinner and others can go and do what we need to do and begin our working day. Nicole, I'm looking at you. Let me say thank you very, very much to you, Jerry, to Cormac, to Hans, to Neil, and to Nicole. Wonderful discussion. I really enjoyed it myself.
Thank you so much, Max, and to each of the commentators. Wonderfully rich comments. Thank you.
Thank you very much, everyone.
Pleasure. Thank you.